let's talk about procedural steps for divorce. What it takes, how long it takes, how much it costs, what needs to be done from the beginning to an end, in a brief summary. So first of all, someone needs to file for divorce in order to get a case number. Someone will be the petitioner, that's the person who initiates it, and the other person is going to be a respondent. So let's say petitioner decides to file for divorce. They lived in the state of California for 6 months, in the county for 3 months. That is the first reason they can file for divorce. They will fill out FL 100 and FL 110 and then double check in their county. If it's San Francisco, another form ADR 11.17. If it's in another county, double check the local forms if there is anything that needs to be filed, usually an ADR form. Once they file for divorce, it costs $435 to file it unless you apply for fee waiver, which is FW001, FW003 form. Then once you file it, that needs to be served. What does service mean? Someone other than you, over 18, needs to take the paperwork that has been filed and deliver it personally to the other spouse. There are different types of service that I don't want to talk about because serving in person is the most effective one and it ensures jurisdiction over the respondent. Then the person who served the respondent would fill out a form called proof of service, FL 115, and give it to you so you file it with the court. You can file it through e-filing, most counties allowing e-filing. Nowadays, if you go to court, they will probably tell you to e-file and explain how, but usually we're using greenfiling.com. Now, you file all these forms, the proof of service. What's next? The person who filed for divorce needs to fill out preliminary declaration of disclosures. Those are two forms, FL 142, which is assets and debt form, and FL 150, which is income and expense declaration form, and fill out proof of service of serving the respondent these two forms. You don't need to file the actual preliminary declaration of disclosure forms because there will be a lot of financial information that the court doesn't need to know. The court needs to know that you served it, so which is the form FL 141, proof of service of declaration of disclosures. Then you file that form. So we already have FL 100, FL 110, ADR 1117. We have FL 115 proof of service. We have proof of service for serving preliminary declaration of disclosures, FL 141. And depending if the other side responded within 30 days to your petition with FL 120, they are required to also serve you with preliminary declaration of disclosure forms. If they didn't file, then they're not required to serve you with preliminary declaration of disclosure form. So if they filed, it's called uncontested. If they didn't file, you can create a default with an agreement divorce. How do you know which forms to file in each of these cases? The judgment checklist is on FL 182. It's called judgment checklist form. There is 4 types of divorces and you can check which one applies to you. I suggest, if you are in good terms with your spouse, to pick the one that's called uncontested or default with a divorce and create a marital settlement agreement. The marital settlement agreement will say who keeps what is separate property, what's community, are you dividing, is there equalizing payment, is there spousal support waiver, is there child support, is there custody. Ideally, of course, you would like to hire an attorney who will draft it as a mediator, not as the representative of either of you, if you would like to save the cost, as a mediator drafting this marital settlement agreement and the judgment forms and file it with the court. From the beginning to an end, if everything is amicable and you follow these steps I just told you, it's easy to do within 3 months to fill out everything. These forms, marital settlement agreement, file it with the court, and then you will get a judgment back that says you're single 6 months and 1 day from the time you served personally the paperwork, the petition to respondent. This is the 6 months and 1 day rule of cooling off period, where someone who files for divorce and the other side cannot be single unless the 6 months and 1 day passed. So which means you might get the paperwork before 6 months expires, but it will say 6 months and 1 day. Nowadays, courts have shortage in staff. Usually it takes 3 to 6 months to even get the package returned. And if you don't follow the guidelines how to fill out the judgment paperwork correctly, which I have a whole YouTube series about that, it will be returned, the whole package, and then you have to resubmit. And then if the clerk finds another mistake, the whole package will be returned until you fix the next mistake. If the court finds a third mistake, so what I'm saying is the court is not going to say, fix 10 mistakes and I'll accept your judgment. The clerk finds one mistake, that's it. They don't have that spam of doing the work for you. So basically, I'm not going to talk about clerks, although I have a lot to say about it. Ideally, you want to follow the guidelines, make sure the judgment is properly checked off in boxes that need to be checked off, which again, I have the video about, and then submit it. Now, why is divorce more expensive with attorneys? The reason for that is when an attorney is looking at your financial disclosures and notices mistakes that you need to fix, that takes time. And those mistakes can be a reason to set aside the whole divorce judgment. For example, if the other spouse finds out that you omitted assets in the preliminary declaration of disclosures, then the spouse, from the date they found out, have a couple years to file a set-aside judgment. There are different rules. I actually have a different video about how to set aside judgment. There are different reasons for different timelines, statute of limitations that apply for fraud, undue influence, omitted asset. So in order to have a really good divorce judgment, I suggest to hire an attorney that will prevent from the other side trying to set it aside for whatever reason. Now, approximately, depending on what state you are, I'm talking about California, it will cost $5,000 to up to $25,000 depending on the issues. If there is no court involved, of course it's going to be less expensive. So for example, you can resolve all issues, but spousal support is an issue. And depending on whether the spousal support issue goes to trial or the other spouse is not disclosing assets and discovery needs to be done, that is also an expense. Child support, child custody, relocation. This is all that's adding up when having to draft a motion, go to court, defend it, go to trial, do the discovery, hire an expert to divide all assets. So, but this is not what this video is about. This is more about the steps. So we know now there's 3 steps: file, serve, prepare the judgment package, and submit. That applies to all divorce cases. And depending on what issues are being disputed, that process can be delayed. So on average, divorce takes about, I would say, 9 months to resolve. And if more than one issue is a problem, that extends the timeline. If you have any questions, ask them down in the comment section below. And I will see you in my next consultation. Bye.